Well, good afternoon, everyone. It is so amazing to see so many familiar faces, especially coming out of such an amazing barristers this past Saturday. Thank you all so much for being here. My name is Gabby Mestre. I am one of your class of 2026 class marshals, and it is a distinct honor to kick off our last lecture series today and introduce the brilliant Professor Robert Sitkoff. Professor Robert Sitkoff is the Austin Wakeman Scott Professor of Law and the John L. Gray Professor of Law. He's an expert in many, many fields. Trust me, if I told you all of his accomplishments, I would be the one giving the lecture today and not him. But he specializes in wills, trusts, estates, and fiduciary administration. Professor Sitkoff clerked for then Chief Judge Richard Posner of the United States Court of Appeals for the Seventh Circuit. He taught at both NYU and Northwestern before joining the Harvard Law School faculty in 2007, where he became the youngest professor to receive a chair in the history of the school. Professor Sitkoff has been published in leading scholarly journals such as the Yale Law Journal, the Stanford Law Review, the Columbia Law Review, the Journal of Law and Economics, and many, many others. Professor Sitkoff is a co-author of Wills, Trust, and Estates, the most popular American course book on trust and estates, and he is a co-editor of the Oxford Handbook of Fiduciary Law. Professor Sitkoff's research has been featured in the New York Times, Wall Street Journal, and Financial Times, amongst other media. He's an active participant in trust and estates law reform. He serves on the Uniform Law Commission as a commissioner from Massachusetts. He previously served as a member of several other drafting committees for Uniform Trust and Estates Acts, including as chair of the drafting committee for the Uniform Directed Trust Act. And on a personal note, I took Professor Sitkoff's Trust and Estate class last year and found it to be one of the best classes I've taken here at the law school. So now, without further ado, I know none of you are here to hear me speak. Please help me in welcoming Professor Robert Sitkoff.
Thank you. That's very kind. Thank you. Well, thank you. That's a very generous and kind introduction. So let me say something about what you just said, and then I'll get into some of the things I wanted to say. So from time to time, people make that comment about the youngest chair. So I'm going to tell you the true story, what actually happened. So I was a visitor here in spring of 2007. Elena Kagan was the dean at the time. This was a good time to visit Harvard. It was a period of promiscuous hiring, so it was a good time to visit. And anyway, the faculty had a meeting and voted my offer. Elena came to the office, and we talked for a while. And then she got up to leave. Anybody know Columbo? Like, she turned at the door. She turned around. Oh, one more thing. If you say yes, you'll be the John L. Gray Professor of Law. I said, oh my goodness, that's amazing. That's really early in career. I was 31. That's pretty early to have a chair. Oh my goodness. And she said, well, the donor restricted it to a specialist in trust and estates. What else am I supposed to do with it? So that's actually what happened. Okay, anyway, so I thank you for inviting me to do this. It's quite an honor. One of the reasons I moved here now about 20 years ago was for you, for the students, your curiosity and energy and engagement, hunger to grow and learn has been exciting and really the best part of the job. It's made me a better teacher, a better scholar, a better lawyer. You have over the years, including the last 2 years, held me accountable, forced me to think harder and deeper about issues. A little bit later in this talk, I'm going to quote a line that one of you wrote in your exam, and I've lifted and put in the casebook as it's a good line. But also, you have been unfailingly generous. As some of you know, the past year or two has been a little bit rough for me. My father died. I got a concussion. Each of my 3 children had significant health issues. One needed a surgery. It's been a bumpy couple of years, and throughout that whole period, you've all been, people taking the classes in particular, have been uncommonly generous and accommodating my bumpiness and not, there was the one class I had to leave partway through to go lie down because of my head and whatever, and so thank you. So last lecture, I hope it's not my last lecture. It could be, but that's not the, hope for the best, but plan for the worst. It's our field's motto. I don't think it's going to be the last. People are laughing. I mean that for real. Hope for the best, but plan for the worst. So I don't think it's actually going to be the last lecture, but I do suspect that for many of you, this will be my last chance to indoctrinate. Right, the last chance to tell you some things that I think are important, that I think are important to me for you to understand as you embark on being a lawyer, as you embark on the journey of the rest of your life. And I hope it's not the last chance. I hope you will stay in touch and reach out and email. Email's easy, right? I mean, Hauser or whatever, but I understand for many this will be. So I puzzled for a little while about what could I tell you? You know, what would I want to do in this last lecture? So the problem is I have a pretty narrow range of knowledge. I know a lot about trust and estates and fiduciary law. I also know about classic Star Trek, coaching Little League, and the Yankees, making pancakes. None of this seemed like really appropriate. So I went back and I gave one of these some years ago. Was it 10 years ago? I looked at that video and I thought, what have I learned since then? And the first thing that came to mind was how to do colonoscopy preps. But that seemed like not also what we should do. I mean, we could, if we maybe the Q&A, we can. So my family said, don't talk about colonoscopy, so I win. There, we did it. So let me tell you what I did. I dug up the outline, dug up my notes from that. And what I was struck as I looked at those notes from all those years ago when I did one of these talks, what I was really struck by was the very different perspective, my very different understanding of what I told that class those years ago. Right? And so what I want to do today, and that reflects 10 years of growth, right? 10 years of learning, 10 more years of experiencing you, 10 more years of just life. And so what I want to do today is I'm going to talk about several of the same things I talked about then, but from a refreshed lens with what is my current state of development. And in doing that, what I'm trying to model for you is the never-ending growth. Right? The idea that you will continue to learn and develop as a lawyer, as a person, as a child, a sibling, a partner, or whatever. The idea that you need to keep learning, you need to keep growing, you want to keep reevaluating what you think you know, and look at these things afresh. So here's what we're going to do. We're going to try to tell you some things that I wish I knew. I wish that I knew when I was you. Right? When I was getting ready to graduate and go out. So I want to tell you 4 things that I didn't really understand then, and I think in truth, I didn't even really understand 10 years ago. I mean, I thought I did, and I talked about them in that talk, but I understand them differently now, and I'm sure in 10 years I'll understand them even differently then. But I want to talk to you about what I think I understand now. You don't have to accept my vision. You don't have to accept these things that I'm going to be telling you. I want to offer this as a kind of as an idea for you to take in and then absorb, and do with what you wish, right? Take this into the full body of your development as a person, as a lawyer, whatever else. But mostly what I want to do is get you thinking. I want you to look at this as a broad picture. You're about to enter a learned profession. And that term learned for a learned profession has real meaning, right? It's not just that we're self-regulating and the like. It's that it's a profession that requires study. It requires learning. People are coming to you for your learning and for what you can think, what you can do for them. And so I want to push you a little bit. So this is going to be a last lecture about the law, and specifically law that you're going to be doing. And even more specifically, I'm going to tell you what I think is I'm going to tell you what is my understanding of the law that many of you are going to be doing and why it matters, and what I think is your responsibility to your clients, to the practice of law, and to society as a member of this learned profession. And I think I narrow this into 4 takeaways, 4 buckets. Let me tell you what these 4 buckets are going to be. So one is not a shock for people who took the class, is I want to say a little bit about the relationship between public and private law. I want to say something about the relationship between public and private law. This is foundational, this is definitional, this is something that we're going to need to be able to have this conversation, which is not really a conversation, but it's the polite way to say it. So to have this conversation, we have to have a common vocabulary. All right. The second thing is I want to say something about private law and private ordering, which is the law that most of you are going to be doing. And I want to tell you what I think it is that you'll be doing and why it matters. And I want to say why it matters because I think that's where rule of law really has power, and I think that's where it affects people on the ground. So the claim I'm going to be making is this is retail law, that private ordering, private law is retail law. This is not just what most of you are going to be doing, but this is what many of your clients are coming to coming to you for in their day-to-day life. And I think it is unfairly denigrated in elite law schools. I think that we don't give enough attention and time to the significance of private ordering. We do not encourage you to go practice in this area. We don't congratulate you for the contributions you make in doing it, and yet we send most of you out to do that. And I think you should feel really good about it. I think it's absolutely essential, and I want to tell you why. Okay, the third bucket, which follows from that, is your role as a lawyer. And I mean this on the one hand as a fiduciary, so as a member of this learned profession to whom your client turns for help, but also in terms of your responsibility for what the law is going forward. It's a long tradition in these talks for folks up here to be telling you about your responsibility as a lawyer, but it's usually in a public law frame and at the end of the republic as we know it, unless you do something or another. So I want to make a subtly different claim. I want to say that your role in policing the reform of private law is absolutely essential to the development law, and even more so now for a variety of developments in the nature of private law. Increased codification, right? The disfiguring of statutory interpretation because of public law battles and so on. So I want to say a little bit about the role you're going to play and what that matters, and that's the public service aspect of being a member of a learned profession. There is a public service aspect in the private law domain also, and that's the thing I want to talk about. All right, so then there's number 4. So number 4 is going to be to tie these three together. I want to offer you a competing vision of rule of law. This is weirdly maybe a subversive notion of rule of law. I want to suggest rule of law as private ordering as private law, right? So instead of talking about rule of law as in the organization of civil society, people in the state, public law, I want to talk about rule of law from the standpoint of we order your personal and professional affairs with other people, and we enforce it, we resolve it, we make it work through law rather than through baseball bat. Right? I'm going to talk about that kind of retail rule of law. And so this is the idea of private law, these forms as rule of law, and then the role of you, of lawyers, in making this all work. Okay, I say this is, okay, so let's go through these first. So first, what do I mean when I say public law, when we say public law and private law? So public law, right, is constitutional law, administrative law, criminal law, and the like. This is the law that organizes the state and your relationship to it. This is the organization of state, right? The coercive power of the state and how this is going to operate. So this is the front page news, right? This is where everyone waits for Supreme Court decisions and writes about that every year. This is what gets these headlines. This is this notion that this is what's going to. This is why we have a leg ray class. This is what, if you pick up the Harvard Law Review, is going to predominate its pages. This is what draws people, because you go to college, take political science. The Constitution exerts this gravitational pull on you. It's very exciting. It's lots of fun. That's fine. So there is a long-standing history in these talks of expressions of worry about the current state of our civil society and whether our public law institutions will be able to abide given whatever crisis is at hand at one of these lectures. And you are exhorted to engage with these problems because the republic depends upon it and the whole order matters. And I'm not saying that there's not something to it, but if you go back and you look at some of these lectures on YouTube, that's what this is. That's what this is about. It's a critical moment in our constitutional republic and whatever else. But I also want to say that's not a new sentiment. So I just took a minute on Google. I'm going to read you a line here. It is not to be disguised that we have arrived at a critical period of our country's history, and that the capacity of the people for maintaining a constitutional government is being subjected to a severer test than ever before. If, however, either the legislative or executive disregard the limits upon their power fixed by the people, what we suppose to be a constitutional republic becomes the mere tyranny of the majority. Okay, that was from the inauguration speech of a governor of California in 1867. You know what I'm trying to say? I'm not trying to say that there aren't challenges today. I am trying to say that the fact of challenges to the public civil order is not a new thing. Right? It's a perennial thing, and it is an important thing, and many people here focus on that and want to talk about it, and I don't mean to say it's not significant. I just want to say it's kind of an evergreen problem, and it is, I think, unfairly eclipsed a different problem, and that's the one I want to draw to your attention, and that is the problem confronted by private law. That's the law of organizing your relationships with other people, with entities, with organizations. Right? This is the law of private ordering, buying and selling things, of jobs, of organizing business, of forming a family, other organizations. You understand? This is retail law. This is your day-to-day. Life. In truth, this is the law that most people butt up with all the time. Right? So we start a little bit late. Why? Because your Sweetgreen's delivery was a little bit late. Okay, is this a breach of contract? Are we going to deal with it? Everything that's going on is all private ordering, right? So my nose in the side, back in my day when I was in law school, they gave us deep dish pizza, which isn't even pizza, right? It's a souffle. It's pizza, everything. It's not pizza. It's always pizza, whatever. So this is kind of fancy. Anyway, whatever, it's Harvard. Okay, so when I say rule of law, right, when I say rule of law, you're habitualized to think about like legal checks on the executive. Right? You're thinking about checks and balances. You're thinking about due process. You're thinking about deprivation of life, liberty, or property, and the like. But I want to suggest something cruder and more base. Right? Rule of law is an organized, predictable apparatus for dealing with breakdowns in private ordering, for being able to make private ordering and understanding that this is not, that it's not going to come apart. Do you understand? This organization not by force, but by rule of law. So if I make a deal to have the Sweetgreen delivered and it's not, I'm not going to go with a baseball bat and beat up the manager there. That we have a way of resolving this dispute, right? That there's an organized way to invoke the coercive power of the state to make sure the deal we struck, the organization that we made, works. Okay, so let's take a step back. Let's be political theorists for just a minute here. So what's our point here? What's the point of organizing in civil society? Right, so all this time we talk about the constitutional republic is in danger and will fall or whatever. Well, why do we care, right? What's the point of the constitutional republic? Someone's like, I don't want to do Locke and Rousseau and whatever. That's fine. What I'm getting at, the point I want to ask is, why are we organizing that civil society? Right? Why do we care? Why do we want this organize the state? Right? We don't organize the state just to have the state. Right? We don't organize the state to just have the state. The liberal, and I mean like John Stuart Mill liberal, right? Like the small L liberal. In liberal society, the point of organizing the state is to facilitate private ordering. Right? It's to allow individuals to flourish and organize their affairs. Right? So the John Stuart Mill idea of liberty is that my liberty is to the tip of your nose, and I can organize around that. So what's the idea of civil society? To police that. So I got to erect this constitutional republic in order to what? In order to flourish. Well, what does flourishing mean to me? That doesn't matter, right? That's my problem to go out and organize. Public law is the infrastructure that lets you then create the system of private law in order to order your life. The point of the ordered society of liberty. Why is it so important you don't deprive me of liberty without due process? What is that liberty? To go and organize my life, to marry or not, to build a business or not, to contract or not, whatever, all of these things. If you think of the civil society as something more than that, you're actually profoundly illiberal in the classical sense, because that was the idea of individual liberty. So that's our first point, right? Public law, private law, that's a sketch of what this is about. On this view, the project of private law is as, if not more important than the project of public law. Right? That's where we're trying to get, to let people go and do their thing. Okay, so that brings us to our second bucket, which is the role of private law. How does this work? What does private law do for us in private ordering? So let's take a step back and think. This probably would have been useful at the start of law school. Just kind of think about, what do I mean by this landscape? We'll start with the big three: property, contract, and tort. Right? Let's start with the first approximation. This isn't exactly correct, but it's roughly true. Let's just start with the baseline that you have a property right in your things and in your person. It's not exactly true, but roughly speaking, you have some kind of right to your body and your things. So what's contract? That is consensual transfer of those rights. What is tort? That's non-consensual transfer of those rights. That sort of makes sense now, right? So we have your rights, that's property, and then we have a contract, that's how you give it away in a deal, or you've got tort, where after the fact we're filling in the deal because it was a non-consensual transfer. So what's everything else? Everything else are specialized applications of that. Corporation, LLC, marriage, trust, agency, partnership, wills, everything. They're all specialized applications of the general of the big three. They're all specialized forms, right? They all reflect special instances of these problems. Well, what happens when the private ordering goes wrong, like really wrong? Right. Well, one, there's criminal backup, or the other, there's bankruptcy. Right. So now we've got some public backstops when this goes wrong. But when you think of it in this light, what's the project? The project is facilitative, not regulatory. Do you understand a little role of the lawyer now? There's this old expression: lawyer is transaction costs engineer, lawyer to make this stuff work. The idea behind these rules is facilitative, not regulatory. It's a really big deal for reasons we'll come to in a minute when we think about cases and we think about drafting statutes. The point I want to make now is that our idea is to allow people to order the way they want unless we have some policy reason not to let them do it. Now, there may be good public policy reasons why we're not going to let you do certain forms of private ordering. That's fine. But outside those areas, we want to facilitate. We want to make this work. So go back to the machinery of all of these areas of law that you've learned. Right? There's, generally speaking, pieces that are for third parties. Third parties need to understand what's going on. And there are pieces for the people involved in the ordering. Everything you've learned and everything you'll be doing, I think, will make more sense in that framework. I'm going to give you examples. Right? It is very common across private law to see formation rules. You know what I mean when I say formation rules? Like, how do you trigger this form? So let's go back to contract. Let's think about contract for a minute. Offer, acceptance, consideration. Think of wills, writing, signature, attestation. Agency, you manifest an intent that someone else can bind you. Or more recently, the written power of attorney, because we want to be able to prove this. If it's a LLC or a corporation that has limited liability, you have filing with the state. All these formation rules, what are they about, right? We're starting to see they're about how we signal to our counterparty and third parties that we've created a form, right? What we're doing. And what do you see inside all of these different areas of law? You see rules of governance or construction or default rules. So you see how there's a common thread across them. What does that look like? Let's go back to contract. So you remember Lady Lucy Duff Gordon, right? Exclusive dealing, where we read the contract to say, well, there's an implied duty of good faith and fair dealing. So that's not just Cardozo saying, well, we're just going to make something up. That's facilitating. Well, these two people made a deal. You're my exclusive seller. Well, the only way that deal makes sense is if you're going to make reasonable efforts to sell. So I'm going to facilitate what is the probable intent of the people here. I'm not regulating their deal. I'm facilitating what their ordering is meant to be. In partnership, corporation, LLC, you'll see rules of profit sharing, of voting, of preventing strategic behavior. Why? Well, these are all what we think are what the parties would have wanted. And to varying degrees, we let the parties say something else. But if they don't tell us something else, we give them these terms. Why? Because we've learned this is what they're trying to do. That's kind of magical. Right? There's something astonishingly beautiful and magical that there is on the shelf all these forms that you do the right formation signal. Right? You check the right boxes. You do offer acceptance consideration. You manifest an intent with someone else to go into a business for profit. That's partnership. You file with the state. That's your corporation. You manifest an intent and give property. That's a trust. Once you do the formation rule, you immediately get all of this stuff. That's not regulatory, it's facilitative. Trust, fiduciary governance, and trustee removal. Or here's another one. This is a little bit weird to think of it this way. Marriage. Marriage is a private ordering form. Right? What was marriage? You go through a formation ritual, right? There's a filing with the state. And then what do you get? You get a marital property regime. That's your default. You might like it or not. You can change it if you don't. And you get dissolution rules. Right? You have rules for dissolution during life, and you also get rules for dissolution at death. You might not like those rules, so you contract otherwise if you don't. Right? So, right, it's a very romantic vision, right? So, like, I said, right, hey, let's have a long-term relational contract for horizontal integration or household production functions. Right? So understand, this is private ordering. Then we'll have, franchisees. It's private, you understand private ordering? Okay. So you don't have to reinvent every one of these things every time, right? The private law is providing that. What's your job as the lawyer? Your job as the lawyer is to understand the objective of the client. Figure out which one of those forms will get them closest to the objective, and then go make it right. Change the default rules that don't fit. Do you see what I'm getting at here? At a first approximation, that's not just a deal, right? That's your transactional side, right? Many of you will be transactional lawyers. What you're doing is you're taking one of the forms and you're jamming what people are trying to achieve into that form. So every time that LLC agreement doesn't have a clause in it is a failure that is needed, is a failure of lawyering, not to understand that the form doesn't fit what they're trying to do. Every time the marriage comes asunder and it turns out those rules aren't right, it's a failure. It means that that we didn't change those default rules to fit what the people wanted. Even tort, like let's use Goldberg, now Dean Goldberg, right? His vision of tort. The Paul's graph principle, right? Tort is all about you have a right, and if somebody takes that right, you're in compensation. Non-consensual transfer, what's his idea of the Paul's graph principle? That it has to be foreseeable, right? If it's not foreseeable, you're taking someone else's right. Do you understand? That's just, we're filling in what the contract would have been. We're giving you compensation for what was taken. So on this view, the private law is just a set of forms. They're forms that to varying degrees let you organize, and to varying degrees let you customize the off-the-shelf form to get at what you're trying to do. Now, I understand there are problematic edge cases, right? We do them in class. That's what's fun, right? So in a contracts class, that's Hammer and Sidway. That's promises not to smoke. And in my class, that's, I'm going to give the manuscripts to the Hebrew University in Jerusalem. Is that a declaration of trust? Is that a gift? Because a gift, those are problems with formation, right? Those are formation problems, and you get a good lawyer involved, we'll solve it. Right, we'll find a form and we'll jam you in. Right, okay. Another way of getting at this, because Passover is coming. When I was in law school, one of my law school classmates invited me to her families for a Passover. They had a tradition. Their tradition is you had to interrupt the Seder at some point and make some unique contribution. So what I did was when they did the 4 children, the 4 questions, the different questions, I chimed in. I got a 5th child, the Chicago-trained child. The Chicago-trained child asks, weren't the 10 plagues just really a failure in private ordering and enforcement mechanisms, that if we had an enforcement regime, we wouldn't have need to kill all the firstborn and whatever? Do you understand? That's what it's funny, but also that's what happens when you don't have enforceable private ordering forms. You have to slaughter people's children to get them to comply. I mean, maybe you'd hit them with a baseball bat. An ordered society is about making ordering work. Okay, so that takes us to the third point I want to talk about, which is your role. So I've already talked about your role as a fiduciary for your client, but also as a member of a learned profession, meaning obligation to society. And I want to suggest that obligation is not, defending the republic from falling, whatever. I mean, that's important. But also making this stuff work so within the society we can flourish. Each person can flourish however they want. So we've talked about one of those, which is being alert to the objective of the client. That means listening. Do you understand? That means a good lawyer is a counselor at law. You're listening. You're getting what they're trying to achieve and helping the client get the right form and customizing the form. Good transactional work involves listening with an empathetic ear, really getting the objective, counseling the client on the ways to get there, and making that form fit the circumstances. That's one we've been emphasizing. I want to talk about two others. One is when dealing with private ordering gone awry. So now we're talking about litigation and lawyering in court and also judging. And the third is going to be your responsibility for making law work. So here's what I want to do. I want to go back to this new case, it's a favorite case. I just started teaching this. But we're going to do, some of you have seen it, but we're going to do it differently now because we're a different prism. Remember this guy? So this is Beck. Right? This is the Beck case from Montana. For those who don't know what happened here, so this guy, Beck, is in his truck, and he takes his iPhone. He makes a recording. Right? He takes his iPhone. He makes a recording.
Give all my possessions. If anything happens to me whatsoever, I give all my possessions, everything, to Jason Beck, my brother. Christina Fontenot does not get one thing, not one thing.
Okay, so we understand what's going on here. Now he's trying to order his affairs. Do you understand? Right? So we have a member of our civil society who is exercising that right that we want everybody in our society to have to order his affairs. Right? He's manifesting testamentary intent. I don't know. I don't think anybody disagree here. This guy is telling us what he wants to happen to his property when he dies. Now, if he came to you once you're licensed, or he came to me, I am licensed. If it came to you, it comes to me, what would we do? Well, I know the forms, right? I'm like, oh, we're going to do this. We can do a revocable trust. We can do a will. I got lots of forms. And I can make it fit, and I can do this right, and I can make sure Christina Fontenot doesn't see a penny. No problem. We're good to go, right? But he didn't, right? Didn't have a lawyer there, right? So there's no transactional lawyer involved, so where are we now? Well, the lawyer's involved after he dies, when his brother brings this to court. When his brother brings this to court and wants to probate it. So now remember I said we got three spots. One is the client comes to you. We're going to help them order. Second is it gets busted, and now we're in court. So what can we do when we're in court? Here the claim I want to make is that our grand debates about constitutional structure, about public law, have disfigured our reasoning in private law cases. Right? We're bringing an inappropriate methodology to these cases. So here's the statute at issue. Here's the statute in this case. A document or a writing added upon a document is probatable if there's clear and convincing evidence the decedent intended the document to be his will. Everybody agrees this guy meant for the video to be a will. Right? The court says so in the decision. This reflects his testimony intent. Nobody's doubting that he wants this video to be his will. It's a statutory interpretation case. Is the recording a document? Is the recording a document or a writing upon a document? Right, that's the question. Okay, that's fine. So let's do the internal and then the external. Here's how the court resolved the case. The court says, well, the statute is clear and unambiguous. It's always a warning, right, when we say a statute is clear and unambiguous. Statute is clear and unambiguous. It doesn't. That the video is not. Okay, why? Well, it says document or writing upon a document. So to be a document, you must be capable of having writing put upon it. This is a recording. You can't put a writing upon that. So a document must be something that has writing on it. It's not a document if it doesn't have a writing upon it. So this is not that, says the court. That's one argument. Secondly, the court says, also we see that there's this Uniform Act, Uniform Electronic Wills Act, which our state has not adopted, but it says to be an electronic will, it has to be readable as text. And this is not readable as text. So that reinforced our conclusion it's definitely not. Okay, that's how the court answers this question. Do you see how the mode of reasoning here? This is about limiting power. Do you see it's a very public law way of thinking? It's the claim I want to make. This is about protecting, about limited power, I'm concerned about the coercive power of the state. None of that's at issue here, right? This is a facilitative statute. This is when I have overwhelming evidence that the thing was meant to be a will, it should be a will. Now, I'm not saying that it's clear that the video is in or the video is not in. I'm just saying there's nothing like that there. The claim I'm making is the preoccupation with public law obscured from the court what to do. And the court wants to think that it's super textualist, right? A writing or writing upon a document and how it's reasoning. And then, of course, it makes this totally non-textual turn to start reading a statute that was never even adopted. Right? Okay. What would be another way to think about let's try another way to think of this. So here's the one of you, I don't know if it was in this room, somebody in their exam wrote this. Well, if you have a statute that says a farm animal or a person riding upon a farm animal doesn't make chickens no longer farm animals because you can't ride a chicken. Right? Suppose you have a statute that says farm animals or people riding upon farm animals. Well, you can't be a farm animal then if people don't ride you. But isn't that exactly what this court just said? Right? If chickens are still farm animals under the student statute, then documents can be documents even if they can't have writings upon them. I know that the drafter of this statute did not mean document or writing upon a document to signal that document means only things writing about it, because it was my friend Larry Waggoner at the University of Michigan who wrote it. And what he was thinking about were all these wills where people scratched something out and they wrote something else in by hand. That's what he thought. And if you were willing to approach this case from a different framework, instead of the disfiguring of public law, instead if you came at this as, this is a facilitative statute, it's actually a uniform act, it has a history, where'd it come from, maybe you decide it differently, maybe not. It's actually, I think, a hard question whether videos fall under the statute. But that would be the conversation you would be having. I don't mean to say, to be clear, and let me just say one other thing. I don't even think the court's right, I mean, we know this, right, that a video has, like, you're all on TikTok. You all know videos can have writing upon them. You understand, like, if the guy had just turned on closed captioning, then we would probate it? That's really weird, right? We hold today that our legislature decided that if you turn closed captioning on, video will is good, but if you don't, video will is not. When it adopted this uniform act that was drafted in the late 80s. Like, I was there in the late, I remember the late 80s. We had camcorders like this. Do you know what I mean? There was no closed caption. It's not how that worked. Okay, so here's another. So what could we do to try to defend the decision? Here's another way to think of the decision. What you might have said was, you might say, you know what? This statute is from 1990. It was drafted by the Uniform Law Commission in the 1980s. Nobody in this period would have thought a video would have been acceptable. But today, lots of people are recording all the time. They are going around making documentaries, right? They are recording what's happening, and our statute seems out of date, but this is a big, giant public policy question, whether or not we're comfortable facilitating, whether this is a form that we want to recognize, whether we think the social costs of enforcing these forms are worth it, and that's too big for me as a judge. I'm kicking that to the legislature. That would be a totally reasonable way to go, right? That's fine. It's not what the court's saying. The court's decision is all internal, right? It's all pretend. It's all, well, the statute clearly answers the question. Maybe not. Maybe it does. Maybe it doesn't. Maybe this is maybe what I'm describing is really what it's about. Okay, so here's a joke that Dick Posner told me when I was clerking. So it's like ever so slightly off color, but only ever so slightly, so it's okay. So here we go, right? Okay, guy's walking down the street, and he comes to this storefront, and there are flowers and art and pictures and beautiful things in the window. And the thing says, it's Moshe's Moil Services. A moil is someone who does the bris, who does the circumcision in Jewish tradition. So the guy goes in the store, and he says, why, you're a moil? Yeah, so you do the brises, you do the circumcisions? That's right. Well, why do you have flowers and pictures and all this stuff in your window front? He said, what would you have me put there? Okay, what? And now you understand about Judge Posner's view of opinions. So what do you want the court to say, right? Like, this is a hard problem, whether or not to recognize video wills, right? But I don't think you're helping anybody by doing this kind of this mendacious statutory interpretation. That's not even true on its own terms. It's not even true on its own terms. So, okay, well, if you do this, if you're going where I want to go, which is either you're going to say, look, this is a facilitative statute, and I could read it both ways. I don't see any policy reason not to let someone do this, so I'm going to let them do this until the legislature stops me. Because it's a facilitative statute, I don't see any problem. Okay, that's what I would do if I was the judge. You don't have to. You can go the other way. You might want to say, well, I'm going to kick it to the legislature, which brings me to the last point, the last thing I want to say, which is, well, that's fine. Right, that's fine. I'm going to kick it to the legislature. But then without us, without you, without the learned profession doing law reform, I think it's a hopelessly naive understanding of the political structure. Never in the history of the world has anyone run for governor or state legislature saying, vote for me because I'm going to update the law of wills to account for new electronic stuff. Put me in Congress because I'm going to fix revocation on divorce in ERISA. Vote for me because I've observed that the spousal forced share, which is part of the default rules of the marriage form, no longer aligns with the rise of non-probate. Do you know who knows that? We, the members of the learned profession who help people with the forms and walk them through. We see where the problems are with the forms and when we can't draft around them. Or we have people who don't know to draft around them. This is not just about responsibility for keeping the law updated, but it's also about legitimacy, right? So there's a horizontal equity point here. And I don't just mean about wealth or access to lawyers. So here's a text message a student of mine got some years ago. People, you've seen this before. Getting on some flights with Dad, we realized we don't have a will. If anything happens, and it won't, Mom lies, bad things can and do happen. Please be executor and divide all things equal. Don't know if this would count, but it's the best I can do. Love you and miss your face. So there's your authenticity, because that's a mom. I miss your face. It's fine, right? This one satisfies the statute because it's a writing. So video, no go. This one does. What is the principal distinction between those cases? Right? That's just, or I'm going to claim, I want to argue it's an arbitrary distinction. It's a horizontal inequality. Like efforts at private ordering are being treated unlike. Right? It's an arbitrary way. And so we want to fix that. So that brings me to the last thing I want to talk about, which is this rule of law. So you're all the time, you're going to hear it at graduation and these other last lectures, all the time you're going to hear about rule of law is endangered and you have to protect the constitutional order and on and on and on. It's fine. I mean, it's not wrong that we need to have that. But that's just the predicate to what matters to people on a retail level. What matters to Mom here is if that plane crashes, he's the executor, and things are split evenly. Right? That's what she's looking for. So what do? I want to suggest that the further obligation is to get these things fixed. Right? There's another conception of public interest, public service, and that is the private law reform apparatus. There's a lot of versions of it. There's the American Law Institute and the restatements. There's the Uniform Law Commission and the Uniform Acts. But there's your local bar associations and the various committees that bring the statutes to the legislature. So how do these little tweaks happen? How does the partnership law of whatever state, the LLC law, the divorce law, the marriage law, the trust law, the wills law, the contract law, how do these things get changed? It's ALI, it's ULC, it's local bar groups. Going to the local legislature saying, we have this problem, we need to fix it. Well, who opposes? Nobody. Why haven't we done it yet? Nobody knows. This is just what we need to make things work. You see what the point I'm trying to make here? Okay, so here's an example. Right, here's an example. So if you've ever noticed, my father died like a year and a half ago. He lived in New York. I'm the fiduciary of everything. I live in Massachusetts. I have a brother. He lives in Florida. Okay, you understand? That's a conflicts of law problem. It's a conflicts of law problem. I got a will and a trust from New York. I got a fiduciary in Massachusetts. I got a beneficiary in Florida. It's a conflicts of law problem. Okay, it turns out that conflicts of law and trusts is all derived from the second restatement written by Austin Wakeman Scott, of Harvard Law School. And none of it works anymore, right? None of it works anymore because it's all based on testamentary trust. It's based on territorial context. None of this works anymore. And nobody knows, right? Courts continue to follow the second restatement. We're getting increasingly bizarre decisions. So the American Law Institute and Uniform Law Commission are doing new projects to have a new restatement and a new Uniform Act. And they're completely rewritten to reflect the realities of on-the-ground practice now. Right? So I'm the chair of the drafting committee for the Uniform Act. Kim Roosevelt, University of Pennsylvania, is the reporter for the restatement. Right? And so we're coordinating. So why? What's the purpose of that? Well, because it's not so weird to see people die with family in another state. That's not so weird anymore. So, okay, why is that important to me? It's important to me because I want to see that right. I want to see that right because that's the thing people are trying to do. And so the thing I'm trying to suggest, I'm mindful that said that I got to keep this tight because people got to get to their classes and if we can open the door to questions. The claim I'm trying to make is that this matters to people on a retail level. I'm not denying that preservation of the constitutional order and checks and balances and due process, that's important, obviously. It's a predicate. I'm suggesting that on a retail level, as equally, if not more corrosive to a democratic republic rule of law is failure of private law to achieve the private ordering that people are seeking. When someone thinks they've got a deal and they don't, they think they've got a business arrangement and they don't, they think there's private sharing and they don't, they think they have a trust and they don't, they think they've made a will so Christina Fontenot doesn't get one penny and they don't. When that happens, it is corrosive to rule of law, as much so as checks and balances, whatever else, because that's not what people are watching. People are trying to make payroll, they're trying to buy groceries, they're trying to make rent, and when private law fails them, the law has failed them. So your role as a lawyer to these clients is to draft it right, understand what they're doing, and make the forms right. And as the lawyer in the litigation, show the court the way. And as the judge, find the way. And as the legislator, to fix it. As the lawyer, to lobby. And if you do this, and you choose as a path private law and that kind of practice, understand that you are as, if not more important to the preservation of rule of law as anybody else. I was going to say something insulting of a colleague. We're not going to do that. It's being recorded. As anything else, as anything, I'm not going to do it. Anything so hard. As anything else, it is absolutely just as essential to preservation of rule of law. Okay, so I know people got 1:30. I can stay and talk if people want to ask questions or whatever, but I appreciate you giving me this last chance, and I thank you for your patience and the indulgence. Thank you.
If anybody wants to ask
he's got one here.
Professor, raise your hand. I'll bring the mic. Perfect.
Oh, in this conversation, what changed 10 years ago? So relative to the talk, so I think there are 2 or 3 things that are different. So one, when 10 years ago, I told the story of how I got into trusts and estates, and including drafting my mother's will, which I'd never talked about that publicly before. My mother died when I was 17, and so the reason how I got into trusts and estates. So that story is out there. I'm happy to repeat it again if people want to hear it, but that was one a piece. The other was I did not have this sense 10 years ago of the eclipsing of the importance of private law in quite the same way I'm feeling it now, right? So and I also don't think that I understood. I didn't have this feel for the role of the lawyer in these three pieces. I mean, I talked about it, but I didn't have it organized in that way. So the big difference is one is this eclipsing, and the other is I didn't like. It's customary in these talks to tell your own story. I didn't do that here. I'm happy to talk now if we want to hear it. Do it again, but that's the quick answer.
Does anyone else have any other questions for Professor Sitkoff?
People running class.
Okay, great. Thank you so
Okay,
much, Professor.
thank you.
We truly appreciate it.